South Africa has decided to withdraw from the International Criminal Court following a dispute last year over a visit by Sudanese President Omar al-Bashir, who is wanted by the tribunal for alleged war crimes, crimes against humanity and genocide. Several African countries have expressed concern that the focus of the Hague-based court has been on Africa rather than elsewhere in the world. The withdrawal of South Africa is to take place only a year after the UN Secretary-General receives notification. After the withdrawal from the Rome Statute, South Africa will no longer be bound to the ICC court. According to reports, a copy of the instrument of withdrawal dated the 19th of October was signed by Foreign Minister Maete Nkoana Mashebane. The instrument of withdrawal reads, and I quote, "South Africa has found that its obligations with respect to the peaceful resolution of conflicts at times are incompatible with the interpretation given by the International Criminal Court of obligations contained in the Rome Statute, which established the court." A researcher at ISS, Alan Ngari, joins us on the line to further unpack this. A very good morning to you. Did you expect this decision, and what do you believe brought about this decision for South Africa?
For having me. Let me first say that the withdrawal of South Africa from the Rome Statute represents a significant step backwards in the fight against impunity for international crimes in the continent. As a government that struggled and successfully vanquished the crime of apartheid, this decision and the manner in which it was done casts a shadow on the long-standing history that South Africa has had championing the rights of its own citizens as well as that of African citizens to a just and democratic society. Was it expected? Yes, it was expected. There has been a number of years in which African states parties to the Rome Statute have expressed concern with the ICC and the way in which it works and the interpretation of certain laws. And as early as this year in January at the AU summit, there was a call for a collective withdrawal of African states parties from the Rome Statute. So it was something that was on the cards. We just did not expect that South Africa would do it right now.
Now, as you said earlier, that this is a step back for South Africa. Tell us more about how aligning with the Rome Statute benefits a country.
Definitely. In African states generally, and South Africa particularly, there has not been laws that specifically address the investigation, prosecution, and adjudication of international crimes. When the Rome Statute was adopted in 1998, it gave an opportunity to states that signed and ratified that statute then to implement it domestically. When South Africa ratified the Rome Statute, it also implemented domestic legislation that then allowed for investigation, prosecution, and trying of international crimes in this country. This is a similar thing that has happened in a number of African countries. So when the withdrawal from the Rome Statute is initiated, what this means is that there's a creation of an environment in which states will be unable, because there are no laws that would allow for this process of investigation, prosecution, and trying of international crimes to happen. This is why this is a significant step backwards in the fight against international impunity for international crime.
And have there been any other countries who have withdrawn from the Rome Statute in the past?
Indeed, it's a very interesting times that we're living in. Just 2 days before we got notification of this South African withdrawal, Burundi's president, Pierre Nkurunziza, signed a law, assented to a law that the Burundian parliament voted overwhelmingly to withdraw from the ICC statute. So this is the second country that has taken steps beyond just the rhetoric of we will withdraw from the Rome Statute. Burundi did it 2 days ago. Its president assented to an act of parliament. But this is the first country that has actually given notification to the Secretary General of the United Nations that there is an intention to withdraw the Rome Statute.
The reason behind SA's withdrawal is the court's perceived bias against African nations. Your thoughts here?
among other concerns, many of which, of course, we believe are legitimate to the extent that where there are contestations between the interpretation of the Rome Statute and the work of the ICC, dialogue, constructive dialogue remains the best option and not this withdrawal. African states have been saying, and particularly South Africa has been saying, following the visit of the president of Sudan last year, Omar al-Bashir, South Africa was placed in a difficult position of trying to reconcile its obligations under international law with respect to the arrest and surrender of President Bashir to the ICC, a man who is wanted for alleged war crimes against humanity, genocide in Darfur. There is an ongoing case before the South African courts, the North Gauteng High Court, as well as the Supreme Court, ruled that the South African government had an obligation to arrest and to surrender al-Bashir to the ICC. And then on the 22nd of this month, or rather the 22nd of the court sent to in its fact. So these are some of the concerns that South Africa has had with the interpretation of the law of the Rome Statute. The ICC insists that South Africa has an obligation to have arrested and to have surrendered al-Bashir to the ICC because Article 27 of the Rome Statute precludes any form of immunity from any official, regardless of their status, whether the head of state or not. If an arrest warrant has been issued for international crimes, it must be adhered to by all state parties to the Rome Statute, South Africa included.
And lastly, before we let you go, how long does it take a country to withdraw? What is the process now that South Africa has given its notification?
Yes, so Article 127 of the Rome Statute prescribes the procedure in which withdrawal should take place. South Africa has issued its note verbal or transmitted the decision or the signed instrument by the Minister of International Relations and Cooperation to the UN Secretary General. And once this has been received by the Secretary General, it will take 1 year for the withdrawal to take effect. I must, however, mention that this process of withdrawal should have been more consultative in South Africa than it actually has been. We do not have in South African law a specific instrument that says this is how you withdraw from a statute, but we do have procedure as to how to ratify a statute. And it involves parliamentary consensus, it involves public consultation. These two aspects did not happen in this decision by the executive to send a notification to the UN Secretary General indicating South Africa's withdrawal from the Rome Statute.
So without this parliamentary approval, does the government have the authority to unilaterally withdraw?
It is our opinion that the process, it does not follow what would be the due process, and this could be likely something that could be challenged in court.
Mr. Ngari, thank you so much for your time and your professional opinion there. That was a researcher at ISS, Alan Ngari, who joined us on the phone line regarding the breaking news that South Africa is to withdraw from the Rome Statute.
There hadn't been any indication that this was something that would happen. And of course, we last heard about it sometime around June last year, and subsequently when it went to court, and government, of course, suffered a backlash, not only from the court, but also from a lot of organizations, the civil society, who are concerned about, the cases that President al-Bashir was involved in, and of course would know the issues in Sudan, including that of Darfur, war that has been going, the conflict has been going for many years now, has attracted global attention.